SJC-12912, Commonwealth v. Julio C. Baez.
Okay, Attorney Scapicchio.
Thank you. Good morning, Your Honors. May it please the Court. My name is Rosemary Scapicchio, and I represent Julio Baez. There are two issues from my brief that I'd like to discuss today with the Court. The first is the required finding argument, and the second is the juror issue. So jumping directly to the required finding argument. For the purposes of this hearing, I'm going to assume but not concede that Julio Baez was the driver, because I think the real question is, if he's the driver, was there enough to get over the rail for a required finding? And I think what's missing from the Commonwealth case is that there was no knowledge, there was no lethal intent, and there was no evidence in any way that demonstrated that he inherently had any lethal intent. And so in this case, I would suggest that the Commonwealth's evidence rests almost entirely on the fact that if you believe he was driving, then he maneuvered his car, and that's it. I think this case actually is even stronger than your decision in Baxter, because in Baxter, the evidence was that the driver of that car, Mr. Baxter, had the shooters in his car prior to, was actually following the victim in the car, had pulled over, and then had at least one of the witnesses had claimed.
Can you walk us through the vehicle movement in this case?
Sure. So
assuming he's the driver and that the shots go off, just walk us through just what's happening and your explanation of that and how that shows there's not lethal intent.
Right. So first of all, there's no evidence that.
A little softer, too.
I'm sorry. Mm-hmm. It's because I come from a large family, and I was in the middle. I had to be heard. But in any event, I would say that in this case, there's no evidence that the shooters alighted from Mr. Baez's car. So the evidence is that Mr. Baez's car is on a side street, that the shots are fired, that there's a situation where he backs up, and that according to the evidence, the two people who the Commonwealth says are the shooters jump in his car. That's what the evidence was. Now, the Commonwealth claims that those were both the Soto people who were both found not guilty at trial, but that's the evidence, that's the maneuver that he made. And there were witnesses who claimed that.
He moves towards the shots. Just describe the detail of that.
So the maneuver is that it was actually forward first and then backed up. And according to at least one witness thought that during that time period, a car was hit. His car hit another car on that street. And there was some evidence of paint that were challenging as well. But the maneuver is driving forward and then driving back. That's the maneuver. And the driving forward was, you're right, towards what happened, and then the driving back was according to the Commonwealth, in order for the shooters to get in the car.
Excuse me, counsel, was that on a corner or something? Could
Yes.
you just talk us physically through, this is the rare occasion where it would be useful to have a picture.
Yes.
Can you draw the picture for us with words?
Sure. So the way that the car is positioned is away from where the shooting takes place. So there's no evidence at all that because Baez was in the car, let's assume he was in the car, he couldn't see what was going on.
It was down a hill.
It was
right?
down the hill.
Right.
So there's no way that he could see what was going on. So whatever happens down the hill, he doesn't have any eyesight to that. What happens is the shooting happens, the car goes forward, the car goes back. The two other people who the Commonwealth say are the shooters jump in, one in the front car, one in the back car. But the maneuvering of the car itself, let's just assume that's the focus of this court. That's all they have. And because this case is so different from every other case that I think we have a required finding issue on, because there isn't that conversation beforehand.
But just even abstracting away from the intent aspect here, but just literally logistically what happened.
Yes.
So you said it has to do with a corner.
Yes.
So there's a T.
Yes, like this.
And then does the maneuvering, is there any testimony based on what the witnesses said that suggests the maneuvering is because the car is trying to turn the corner?
No, the car turns the corner after the two shooters jump in. That's when the car turns the corner, not before.
So it's approaching the corner.
Yes. Then backs up, the two shooters jump in, and then it takes the right. That's how the evidence comes out at trial. That's where it was. But that alone, let's assume they were the shooters, okay? Let's assume that they get in the car. Where is Mr. Baez's lethal intent? This isn't a situation where the shooters alight from his car. This isn't a situation where he provides.
Isn't that a reasonable assumption that the shooter is alight from the car if he's picking them up?
No.
Really?
Not at
So-
all.
So the gun goes off and he runs over there, but he's not the guy who dropped them off?
Right.
Really?
Well, because you need
Really?
some evidence for that. So the Commonwealth had presented no
not a-
evidence that he dropped them off, and you can't infer that from anything. The evidence was that the two shooters were sitting on steps.
What do you infer then from them picking up, just he had some plan of picking people up around there and
Well,
guns go off? I'm just,
Best case scenario is that,
because again, this is in the light most favorable to the Commonwealth.
right, in the light most favorable to the Commonwealth, where is the lethal intent? Where is the evidence of lethal intent?
I'm trying to get to the fact that you say that you can't reasonably infer that he dropped off the people who he picks up. That's tough for me. I just want to make sure I understand the logic of
Right.
that.
And so the logic is, who knows how they got there? We don't know how they got there. All we know is the evidence that the Commonwealth presented is that the two shooters were sitting on a stoop. They got up, they pulled their hoodies over their head tight, and they went and conducted the shooting. That's what we know. And we know after that, they fled in the direction of where Mr. Baez's car was. Absolutely, without question. But that doesn't mean that Mr. Baez dropped them off. That doesn't mean anything. Even if you want to believe Mr. Baez dropped them off, there's still no lethal intent because there's no indication that there's any conversations with the shooters. What if they went there to beat these people up? What if that was their intent? That's not a lethal intent. And that's what's wrong with the denial of the required finding. Because you can't infer a lethal intent from no evidence whatsoever. So even if you take it as far as you want to take it.
Counsel, can you address what happened after the shooting, and how that informs or doesn't a jury's ability to find lethal intent?
Well, I would suggest it doesn't because the
But
Commonwealth.
what was the evidence, just to reflect, and then we can deal with the legal
So the
ones.
evidence after the shooting was that the keys for the car get given to someone who gives them to my client's mother. The police end up taking the keys at that point. There is a conversation, according to the Commonwealth, between my client and a friend where he says, I was the driver, but I didn't have anything to do with the shooting. That's the evidence.
And was there a police interview?
In this case,
Yeah.
no, I don't believe so.
Okay, great. Okay, so now why can't any inferences be drawn based on that?
On the fact that he said he was the driver?
And he gave the keys to Figueroa.
Right. So the inference you could draw under those circumstances is that there was a shooting that he may have been involved in, but still you're missing the knowledge and the lethal intent. And those are the two elements that are required in order for this court to determine that the denial of the required finding was reasonable under the circumstances. And I would suggest that that's the key here is, did the Commonwealth sustain a reasonable inference beyond a reasonable doubt that Baez had the lethal intent? And I would suggest, even if you add in the fact that, and there's no evidence of that, but I'll give you the fact that he might have drove them there. And I don't think you should find that because I don't think there's any evidence. But even if you give them that, there's no conversations, there's no supplying a weapon, there's no indication at all that he knows that they're going to go and try to kill someone. There's nothing. And there isn't even a situation here where after the shooting, there's weapons displayed while they're jumping in the car, nothing like that. At best, they have an accessory after. At best, that's what they have.
Wasn't there testimony, though, from one of the eyewitnesses, multiple eyewitnesses, that one of the shooters was, openly carrying a gun as they ran up the hill?
But not in the line sight of Baez. That's the problem. The evidence was by the time the two shooters got to the car, both of them had their hands in their pockets and they jumped in the car. That's the evidence.
So the neighbors from the window at the top of the hill, none of them saw the weapon?
No, none of them saw the weapon. But even if you want to believe there was a weapon, the weapon is displayed on the hill. There's no indication that there's a weapon at the time that either of these two shooters get in the car. The evidence, in fact, is the opposite. The evidence is both of them had their hands in their pockets as they got in the car.
How far were they from? How far was the shooting from?
About a block away,
So
up a hill.
there's an inference that he heard the shots, right?
Right, and there's an inference, certainly he heard shots. And if he heard shots and he moved as a result of those shots, there's a lot of times that people hear shots and want to get out of the area. I don't think that alone displays any lethal intent. And again, when we talk about lethal intent, we have to talk about the ideas that in this case, there's just no evidence to suggest that he knew what was going on. Even if you put the other two defendants in the car at the time.
Ask about so when the two people with the hoodies are walking up the street,
Yes.
their hands are in their pockets, right? And one one of the people in one of the stores gets frightened by them.
Yes.
Does he see a bulge in their pockets? Well, what frightens him?
It doesn't say, there's no evidence developed as to what frightens him. As a matter of fact, one of the issues, I think there's a footnote in my brief.
How does he describe the way they look when they're walking?
He says that they're scary, that
their
they have
hoods are tight around their face.
hoodies are tight and they're walking in. And this individual got, I think
And
he
their
said, a
hands are in
creepy
their
feeling.
pockets? Their hands are in their pockets?
Yes. Yes,
And
but that's-
nothing more about the pockets?
No, but even if you want to focus on that, that's not something Baez can see all the way at the top of the hill.
Well,
He can't see
but
it.
the question is, if they can see them if some guy who's sitting in a store can see a bulge, now, I'm not saying he can, but if he is the driver to the place and he sees them come back, but if he saw them leaving and he could see the bulge, that would be relevant, wouldn't it?
It would, but that would be a gigantic inference not supported by the evidence.
I'm just trying to make reasonable inferences and figure out
Right, but I don't
which
think
ones.
it's reasonable to suggest that, because the evidence, I think there's a footnote in my brief, I can't remember which page off the top of my head, that says that one of the things that happened in this case is that nobody went back and asked that individual, why did you feel like they looked scary? What happened? That's part of the evidence that's missing. Because I agree, if they said the pockets were bulging, something about I knew them and I thought they might be shooters, anything like that, but that's not the evidence. In fact, that was one of the issues on cross-examination about whether or not there was any follow-up to this person who said they look scary. And there was none. There was no interview. There was nothing that suggested what caused that individual to claim that these two looked scary. That's it. All we have is someone decided two young black kids look scary in an all-white neighborhood, and now here we are. That's not enough. It's just not enough under the circumstances to prove lethal intent. And especially when you add that to the fact that in this case, there's no evidence that Baez participated in a plan. And what the Commonwealth wants to say is because the car moved back and forth and because he was waiting there and the shooters jumped in it, there must have been a plan. And that's just pure speculation.
Well, there was certainly a plan to pick them up, right? I mean,
But I'm talking about a plan to murder. I'm not
no,
talking about a
I
plan.
get,
That's
I get.
accessory after the
There's a
fact.
plan of some sort. The question is, was there a plan? Is he involved in a plan to shoot the victim,
Right.
as opposed to a plan to do something to the victim?
Right. And that's the whole point. The whole point of the missing link of lethal intent is that we don't know what the plan is. Typically, we would have conversations, text messages, a witness testifying that he said this, that, and the other thing. We don't have any of that in this case. Not a single indication of a plan other than the moving of the car and that the shooters get in. And I agree, there's a plan for something. At the best, there's a plan that he was picking them up from something. But the question is, what did the Commonwealth prove that something was? And I would suggest that the Commonwealth failed to prove that that something was a lethal intent at all, or even an intent to do any more. What if they were just going to go there and have a conversation and get into a fight? We don't know if that happened in this case, because when the evidence came out the way that it did, and when the defendant...
When he drives off in a rush,
yes, it's not a rush.
well, he smacks the other car and doesn't stop and give his license, right?
Well, the evidence is, initially, the witness who was watching from the apartment building said on direct examination that the car sped off. On cross-examination, what the witness said was
the car hit a car and didn't
Right.
stop and
Right.
give his license to the, do all the things you're
if
supposed
you
to do.
believe the car was hit in the light most favorable to Commonwealth.
But that's clearly, we clearly have to,
Absolutely, Judge.
so, okay, so he does drive off, hears shots, I'm not saying it's proven, but I'm just trying to take all the facts as opposed to
I understand, but here's the
breaking them
problem
apart.
with that, is that when it comes down to exactly the minutia of what he did,
Mm-hmm.
the car was going about 5 or 10 miles an hour. That's not speeding off. That's not 20 miles an hour. 5 or 10 miles an hour is not speeding.
Two guys shoot somebody and jump into your car, you hit somebody, you're going away. You
Right,
know-
accessory after the fact. I'll give you that any day of the week, but it's not a lethal intent, and it's not proof that there was knowledge of what was to happen before the shooting took place. And to answer your question, because I didn't get there, in terms of what happened after that would infer anything, the Commonwealth at trial tried to suggest, and on appeal suggests, that there was a consciousness of guilt, and therefore the consciousness of guilt should be added. But this court has already said, even if you agree that consciousness of guilt, it doesn't go to the intent at the time that the crime was committed. So even if you want to believe there was a consciousness of guilt, there was a flight from the scene, there was a hitting of the cars, if you want to believe all of that, it still doesn't go to the lethal intent. And again, that's what's missing in this case is the lethal intent. And that's why, if you look at this case as compared to Baxter, if you look at this case as compared to Gonzalez, the facts, I think, in this case are even weaker than in those two cases. There is no motive here for Mr. Baez to have engaged in anything. There's no explanation other than he was in the company of the two Soto brothers prior to leaving the party where they were smoking and drinking for a period of time, and he came back 2 hours later. That's the evidence. And if you put him in the car and he's sitting at the top of the hill and the shooters jump in the car, all of that still fails to prove knowledge and lethal intent. And the inferences that the Commonwealth is asking this court to draw, I would suggest are not reasonable based on the evidence. And even if we get to the point where we say he must have dropped them off, even though there's no evidence to that effect, even if you get there, I would suggest under the circumstances, there's still not a lethal intent, and there's no evidence of knowledge.
Counsel, can I ask you to address the jury selection issue?
Sure. So the jury selection issue in this case is that there were all three defendants were Hispanic males, young Hispanic males. So the challenge in this case by the Commonwealth, juror 177 was a Northeastern student who happened to be Hispanic. Even though he was a student, he indicated that he was a very good student, he could keep up with his classes, he wanted to serve. The Commonwealth challenged him. And at that point, there was an issue about whether or not that was a proper challenge. The judge decided at that point that there was no abuse of discretion, there was no pattern. The second juror on day 4 gets challenged, that's juror 18, also a Hispanic male. And at that point, there is a comment by one of the defense attorneys that says it's beginning to look like a pattern. And what essentially the judge did is said, no, it's not a pattern, because we have one Hispanic female from Colombia on the panel already, and we have an African American person on the panel. That neither of them are what was challenged here.
But she doesn't say that, right? She says that the jury appears diverse. Right.
No, there is evidence, not just diverse. She does say the words that there is an African American and a Colombian.
She's walking through what she thinks is on the jury at this point.
Yes.
Right?
And the issue with that is that that's only one factor that the court should have considered when considering whether or not the challenge was racially based.
But we don't know whether she was considering other factors, too.
Well, there's no evidence she was, so I think.
Well, the fact that they're students, no other students have been seated, right?
Not at that point. Mm-hmm. So there was an Indian. No, I take that back. There was an Indian, Indian young person.
He wasn't seated, right? You challenged him, or
well, I didn't, but yes, the defense challenged him.
Yeah, co-counsel.
Absolutely.
Yeah.
But he was, the Commonwealth did pass on that, suggesting that it wasn't young people that they were concerned with.
Well, students. There's
But
a
students
pattern,
that they were concerned with.
There's
But
a pattern of.
But here, the pattern is that race. It's a challenge to race and gender. So the challenge was that the two people that were challenged by the Commonwealth were both both Hispanic males. And so it's not just race, it's not just gender, it's both. It's race and gender. And the suggestion in this case is that the court didn't take into consideration the factors that the court should have taken into consideration in determining whether or not the defendant met its burden of proving that there was a race-based challenge in this case. And once there is, because we never even get to the first step, we never get to was there a pattern, because what the trial judge did in this case is determined by looking at the jury that because the jury appeared diverse to her, that there was no need to go further than that.
Counsel, it's pretty, it seems like it's a fair inference that if you had gotten to step 1 and if the judge had asked the prosecutor, what's your reason for challenging these students, that the prosecutor probably would have said, they're students. And so what is your response to that?
Except for the Indian person. The Commonwealth didn't challenge in this case. So in terms of challenging students, the fact, the first time, first of all, the Commonwealth brings up the fact that the reason for challenging was that they were students is in the appeal. Never happened at trial, never part of the record, never indicated.
I thought that there were comments from one of the prosecutors in the record that, quote, there are lots of reasons I don't like students, and that the prosecutor actually had specifically said he didn't like seating student jurors.
Yes, that's true. But there's a part of our argument as well that says and I know I've argued this before this court, that if the reason was age-based challenge, then we're saying that was also improper. So even if it was based on age.
You've lost that one a few times.
I have, but I'm not done.
You're not done, I know.
I'm not done arguing. Losing that issue is not going to stop me from continuing to bring it
keep
up,
going.
because at some point, I think the racist nature of challenging these students is going to come to fruition.
Can I ask one further question? Is it clear, and I apologize because I probably could have figured this out, but is it clear that the Commonwealth forewent challenging the student who was of Indian ancestry, right? Or did the defense exercise its peremptory? It's very clear that they passed on challenging.
It's clear the Commonwealth passed. They didn't challenge, and the defense exercise. One of the defendants exercised a peremptory challenge to this particular juror. And I think the record was that this juror had some police officers in their family, and there was one other reason. I know it's in my brief. I can't remember off the top of my head the reasons that the defendant indicated that they were challenging this particular juror after the Commonwealth had passed on the juror. But I believe it was the fact that the juror had some family connections, and I can't remember the other issue.
But is that just tactical? The Commonwealth knows the defense counsel is gonna exercise a peremptory, so it doesn't need to do anything. It's sitting tight.
Well,
You've got to, I mean, realistically, we've got somebody who's related to police officers. I don't need to exercise my peremptory because I know what the defense is going to do, right? That happens.
That's certainly
happens a lot, right?
I'm not going to say it doesn't. It's certainly probably a strategic reason, but it doesn't cure the fact that even if one juror was excused based on race and gender, that it's improper. And from this record, you can't determine that it was. Because the trial judge didn't follow the steps that this court said should be in place at the time that somebody makes a Baps and Soars challenge. And that's the problem with the record here, is the record suggests that of Hispanic males, they challenged 100%. Both Hispanic males that were cleared by the court were challenged by the Commonwealth, 100%. And that's unacceptable. And even if you want to take it out of males and just focus on race alone, it's 66%. Because they challenged everyone except for the Colombian woman who ended up sitting on the jury. And in this case,
we don't lump, right?
We do not. They lumped, but we don't lump. So that's the other thing that the trial judge did. Is she lumped together.
We don't lump.
I understand that, but the trial judge did. And so you have to look at whether or not what she did was erroneous. And so if she lumped in race and gender all together and made her determination based on the makeup of the jury, then that was wrong. And what here Mr. Baez had to prove, and I believe that he made the limited showing necessary to make a prima facie case of racist discrimination with respect to the Commonwealth's challenges to make against Hispanic jurors. And I'm asking this court to reverse Baez's conviction based on that. And if there are no further questions, I'll rest on my brief.
Okay.
Thank you for your time.
Thank you. Attorney Lynn.
Good morning, Your Honors. May it please the Court. Paul Lynn for the Commonwealth. I would like to start with the peremptory challenge issue because I just
Actually, let's start with the sufficiency.
I
Please.
mean, can you start with Baxter and distinguish?
Oh, absolutely. Yes, with the Court is interested in that.
Yeah, we're
Obviously,
interested
we are
because it's
dealing-
going to be hard. So
Yes.
help us out here. And
Yes.
you didn't have a lot in your brief on this, and this is tricky, right? It's awfully close to the other case. So help us out here.
Well, I think
Very
the
specifically.
distinguishing factor here is that the defendant has no reason whatsoever to believe that these gunshots have anything to do with him unless he knows that his companions are committing the shooting, are going to commit the shooting, and have indeed committed the shooting. This is a case where actually the lack of evidence that he dropped the defendants off and saw the shooting is actually in the Commonwealth's favor. It is essentially the curious incident of the dog in the nighttime. It is the negative evidence that actually, the evidence of a negative that actually proves the positive. in this case.
But I don't understand that
Yeah,
at
I
all. Can
lost
you walk us through that a
Certainly.
little bit? Because it
He
seems
is-
to
he
me
is out of sight.
that this
He is-
case is actually stronger than Baxter in
Yes.
terms of the defendant, if you can assume it's the defendant in the car, being just the getaway driver and not knowing that there is a plan to kill the victim.
Because if there is no plan to shoot, he has no reason to believe that this shooting has anything to do with him, and yet he knows that. We know he knows that because he pulls forward. As soon as he hears the shooting, everyone goes to their windows. Cape and Cherry, Benjamin Cresser, I believe it is, Ms. Margot, they all go to the windows. And I should add that Margot actually does see one of the men, I believe the man in the light hoodie, carrying a gun. By the time they get up to the top of the hill, and Cape and Cherry and Benjamin Cresser see them, it's apparent that they put their hands in their pockets. But yes, he is running with the gun. Also, the Mrs.
Let's do this chronologically. Help us out here a
Yes.
little bit, because I'm a little confused about. Do we have direct testimony that what triggers him to move the car is the gunshot?
Yes, everyone goes to the window when they hear the gunshots.
And he immediately starts driving towards the
Yes,
gunshot?
as soon as they get to the window, Cresser and Pancheri see the car moving forward, starting to take that turn to the right. And I do want to, before I get too far into this, I do want to describe the intersection because it is important and we could use a map here.
But can I just ask you to pause there, though? Do the witnesses see him parked, gunshot, then move? Or do they all run to the window after the gunshots and the car is already moving?
It's the latter. They hear the gunshots, they go to the window, and they see the car moving. The car goes forward, starts. Well, again, this intersection, it's the corner of Salem Street and I believe High Street, and High Street is the T, but just a slight zigzag to the right is Pearl Street, I believe is the name, and that's testified to at trial. So you make a quick right, and then you immediately go straight on Pearl Street, and that leads away. That is pretty much the only street in that warren of streets on Beacon Hill that goes to the other side of the hill, as opposed to bringing you back around and down to Main Street. So the position, and there is evidence to that effect too. So the positioning of the car is also relevant. He is in a position to get away quickly and not have to return to Main Street.
Right, but I get a lot of that. But okay, and I'll give you that I don't find it compelling that he's not dropping them off. But how does his moving towards the gunshot, couldn't the gunshots, he may be moving towards them to rescue them. You know, how does he know that they fired the shots because of that?
Well, he doesn't have any reason to believe they're being shot at, unless he believes that there's going to be a gunfight. There was going to be a gunfight.
But he heard the shots.
Yes.
And so that's when he realized that.
There's a gunshot.
Yeah.
There's a gunfight when he hears the gunshots.
Right, but how does he know that has to do with his companions? The only reason he knows that is because he knows they were going to get into a gunfight.
Because he hears the gunshots and moves towards his companions. I'm just asking. We draw the inference that he knew they were going to shoot.
Correct.
And that's the trigger for him to drive towards.
Exactly. That's what the prosecutor argued in closing. That's what the Commonwealth is arguing here. And he moves forward. He doesn't flee. He moves forward and then pulls back, so he's in the perfect position. And he does it quickly enough that he hits this other car. And I think the evidence is clear from the fact that the owner of the Jetta, which is the car that's hit, testifies that damage wasn't there earlier in the day.
So now help me on, you say that some people observe the two other people, their guns are out. Are their guns out before the gunshots or after the gunshots?
After.
So there's no test. Again, I'm wondering, is there any evidence that should suggest that when they leave, again, I take it as reasonable inference he's dropped them off.
Correct.
That anyone sees them walking with their hands out or bulges in their pockets or anything that indicates that someone observing them would know they're armed?
No, but Aiden Newhall does testify that when he sees them walking past the car, their hoodies are cinched up, so there's only a little bit of their faces showing. He says one of them is walking funny, although the Commonwealth concedes that one of the Sotos had a limp. And they're engaging in conduct which could very reasonably be inferred to be casing the store to see who's there. So
Why-
it's not just
what
that they're
is-
black
what
kids
is-
or
what is
Hispanic
that?
kids in a, sorry.
Why is that? I'm confused by that.
Because
What is it-
they go past the store, then they go up the hill, then they come back and go past the store again.
Right,
and
but
then
there's
the
no
Lawton-
bias evidence related to that at
What?
all. There's nothing suggesting or tying the defendant in this case to that casing, the
Correct.
hoodies.
Correct.
Nothing. Okay.
But it's, we know for a fact that they weren't there for a meeting. They weren't there for a rumble. They were there to shoot people because that's what they do. They suddenly turn around and without any provocation, shoot the victims. So
They were seen sitting on a stoop for a period of time before this. Is that
there's some question as to whether or not those are the same people. They're not in the correct place. The prosecutor did not rely on that in closing. It's that testimony was there for what it's worth. But yeah, it is clear to
Sorry, the jury
everyone-
acquitted the two co-defendants?
Correct. That is correct.
Help us out explaining why the Baxter is, what is different from Baxter here? Just summarize why these facts, because Baxter, we come to the opposite conclusion, right?
Right, and I anticipated that question, Your
Yeah,
Honor.
no, I'm sure you did.
But I think the difference is you have the circumstances of that case, because the defendant drives the shooter to the scene, lets him off, and then just parks off to the side.
after following the victim in
After
the car?
fall, yes, after clearly stalking, I think would be a good word for that, is so he pulls off under those circumstances, and then the guy just runs to the car. So in those circumstances, you clearly have evidence that the defendant knows that his companion is up to no good, but what this court ruled is that there's not enough evidence, certainly enough evidence to convict the defendant of assault, but not enough evidence to convict him of murder.
But so, and that's where I get confused a little bit here, because I get you. The defendant here knows these guys are up to no good.
Correct.
But does he know they're up to no good in a different way than in Baxter?
Yes, and that we have that evidence
It's
here.
it's the gunshot.
It's the gunshots. It's the fact that the gunshots are what motivates the defendant to act, and that's an almost inescapable. It doesn't have to be inescapable.
In
of course.
Baxter, there were no gunshots?
There were gunshots. There's
Okay.
no question, but there was the difference is that what the defendant did in that case was the evidence before what happened that determined the case.
Did, in Baxter, did the defendant flee once the two co-defendants?
Yes, absolutely. Took the car, took the shooter, fled the scene.
Can I ask you to go back to something you said a few minutes ago, which was that this maneuver, which your entire argument is really resting on, I think you said, quote, left him in the perfect position.
Yeah.
Can you elaborate on what you mean by that?
It means he's out in the street, so he's presumably parked because he's coming out from in front of that car, the Jetta, and he pulls forward and then he pulls back. So now both of his doors, both sides of his car, are in the middle of the street. So that means that these two men can run up the hill and immediately get in the car from both sides, which is what they do.
But why would he go forward in the first place?
Yeah, so he has room to back up. He has to go forward, or he can't back up. There are cars there. That's the problem. That's the Jetta. The Jetta's in the way if he doesn't move forward.
So he's in the middle of the street.
Correct.
Pulls up past the Jetta, pulls back.
No, he's
hits
in,
the
he's
Jetta,
in, he's
and
in
then
front of the Jetta, and he pulls up and then pulls back. And as he's pulling back, he doesn't give himself enough room, and that's why he hits the Jetta.
But he didn't turn the corner at that time.
No, he did not turn the corner. He approached it.
So why I still am not understanding. I'm so sorry, but why couldn't he just have, in the first instance, why doesn't the car just go straight into the spot? He's driving down the middle of the road.
He's not. It doesn't start out with him driving down the middle of the road.
Where is he when it starts?
Right. He's over slightly. He's over more towards the edge because of course he can't sit there and block traffic for however long it's going to be. So he's out of the way, and that's why he has to move forward and pull back.
What is the difference in terms of reacting to shots in Baxter versus here? Why is this more directly connected to the shots than the driver in Baxter?
Because in this case, the defendant has no reason to believe that anything, has no reason to believe that the gunshots are related to him unless he knows that his colleagues are armed and intend to shoot. Because otherwise, it's like, oh my God, there's a shooting, I'm getting out of here.
But his friends are by the shooting. I mean,
what?
why isn't it just as likely that he wants to make sure his friends are okay? There's shots fired.
It's not just as likely.
Why?
And the evidence is in the light most favorable, all reasonable inferences must be drawn in light of the Commonwealth. And the idea is, what would make him believe that they're being shot at unless he believes that they're going to be involved in a gunfight?
I get that, but I'm trying to understand why that doesn't apply equally in Baxter.
I would argue that it very well might apply equally in Baxter. To that extent, I think that...
So you want us to backtrack from Baxter?
Yes, I think it would be, yes, exactly. I
And
think
so
it
do
is
we then
reasonable.
also backtrack from Gonzalez? Is that your
I
suggestion? We
think-
should sort of
I think to the
reverse this
extent that
whole
you're-
jurisprudence? We should reverse this entire
I
jurisprudence?
don't think you need to reverse the entire jurisprudence.
So
You
tell
just
me
need
how
to-
this is different from Gonzalez, where there's actually a motive and the defendant attributed to the defendant. And here, we don't know any reason why this defendant would have had a beef with the victims.
I think you have to look at the facts of all three cases and say, in this case, there's a reasonable inference. Whether or not this court was correct in saying there was not a reasonable inference in Gonzalez and Baxter is immaterial. The bottom line is...
But we have to distinguish, if you would like the court to affirm this, absent reversal of Gonzalez and then Baxter, you have to distinguish it, not us, you do.
Correct.
Yes, and
But
so
I think
how are
can
you
simply
distinguishing?
say, under the facts of this case, the only reasonable inference, and certainly a reasonable inference in the light most favorable to the Commonwealth, is that the fact that the defendant reacts to the gunshots can only be explained by his knowledge that his colleagues are armed and
Is there a
intending to shoot.
case, so Ms. Capiccio is relying on Baxter as being the closest analogy. What's the best getaway driver case from your perspective, if it's that we should look at where we actually affirm these as for lethal intent?
Well, I think the Watson case, which I found while I was researching, it's a little different, but I think I'll have to get the cite to this court, if I may, is a decent case. But really, the Commonwealth is relying simply on Lattimore in this case.
Tell me about Watson.
Watson is a case where the defendant, again, drove the shooters to the scene. Now, there was a little more evidence than that. But certainly this court in that case found that under the circumstances there was sufficient
But
evidence.
What was the little more evidence?
I would have to go back and review that further.
Okay, no, that's okay, I'll do it.
Are there other cases? I mean, we tend to rely on the cases where they've seen the guns or they've talked about the guns.
Correct.
So is Baxter and Gonzalez the only sort of cases where we don't have any evidence of anyone seeing the gun? And is that the dispositive factor?
I don't think it's dispositive. I think you look at the facts of this case, you look at the circumstances of the case, you see that this clearly was an execution. This was not a feud. This was not a.
But again, that goes to the two shooters. I'm wondering why that should go, and I think the case law requires you to show that intent of the shooters is joined in by this driver.
Of course, Your Honor.
Right.
That is absolutely the Commonwealth's burden. But
And
I think
was Baxter an execution case too? though?
Yes.
they certainly came up behind him and shot him. Yes.
Yeah, so we got, that can't be the dispositive factor then. Yeah, it's hard.
It's a close case, but I think if you look at everything, you look at just the simple fact in this case. That
And the
the defendant, we may not know whether he dropped them off, but it's even more inculpatory if he didn't, because we know he has an arrangement with these two men to pick them up and drive them away. That's clear beyond any
But,
doubt.
but
There's
counsel, I mean,
direct evidence
the
of that.
plan could have been for them to steal something from the store, right? We don't know what the plan was. Like, I totally concede that there's clearly it's very clear he's waiting to meet them, right? Like, that is very clear. But the Commonwealth has to have some evidence
True,
of a plan.
right?
And the plan can't be just to pick them up.
Correct.
And it can't be
Absolutely.
just to pick them up in circumstances when they may want to depart quickly because they've been up to no good, to use my colleague's expression. So what precisely, and then you're saying that the evidence is, well, there were gunshots fired.
Correct.
That he could hear.
Yes.
So therefore, it was a plan to kill people.
Yes, I mean, otherwise he has no reason to believe this involves him.
But we don't know, how do we know that he knows that the gunshots involved him in some way? He
Because
knows
he-
that he's picking
yes.
up his friends
Right.
from this location, and he hears gunshots, and that would presumably be very alarming to anyone
Correct,
who's
of
waiting to pick
course.
up their friends.
Right. But he doesn't, at that point, he doesn't have to, there's just no reason he has, obviously, even if this are just random gunshots, that's not his cue to move. It's like his cue to get out of there.
Well, not if he has a plan to pick up his friends.
True, but it's not, the idea is if these are random gunshots, he doesn't have to do anything. He just needs to get these guys out of there. And there's
that
just
what he
no
did?
reason for him to believe these gunshots are anything but related to him. The only way he can believe these gunshots are related to him is if he knows that there's colleagues' gunshots.
Can I ask about Gonzalez for a second? Was Gonzalez another execution case, or was it a botched robbery or something? I understand, there's clearly a plan to assault somebody here or do something to them, because there's not we're not dealing with a robbery or a plan to steal something. We're dealing with, it looks like right? There's no evidence that this is a botched anything, but it's an execution, right?
Right.
Right. Was Gonzalez different and more like a botched robbery?
I concentrated my preparation on Baxter. I will have to look at Gonzalez again.
Okay, we can read Gonzalez ourselves.
Yes. I do want to turn very briefly to the peremptory challenge issue, because there are a couple points I want to make. The first is the defense at trial never challenged Hispanic men. Regarding the first challenge, the defense counsel just said, I want to put on the record that this is a young Hispanic male jury for purposes of the bats and swords analysis. He does not object to the challenge. And then regarding the second man, Attorney Sack, who represented one of the co-defendants, says, this is the first Hispanic, I object to this peremptory challenge because this is would have been the first Hispanic juror we've seated. And he says juror, not man. And the prosecutor says that's not true. We have that woman from Columbia. Attorney Sack says, oh, okay. And that's the last of it. He never says anything about men. I also want to point out that the juror number 18 on day 4 was not the second Hispanic man to be found impartial. Juror number 38 on day 2 was a Mr. Martinez. He was also found to be impartial. The prosecutor did not challenge him, and he was stricken by the defense. That's at 2A, pages 110 to 121.
Sorry, was this before or after the second?
Before.
So
Day two in the morning.
Martinez is accepted before the challenge to the second juror.
Correct. And regarding the Indian juror, the dispositive factor isn't that he's Indian, although that certainly is some evidence of lack of bias. The dispositive factor is that Attorney Amabile for the defendant questions him extensively about a statement he made where he said, I think Hispanics are statistically more likely to commit crimes than other people. And then Mr. Amabile says, I want this juror stricken for cause. Also, of course, the grandfather, who was a police officer and a very important police officer in India. And the judge says, no, I think he just meant that was a statistical fact and he wouldn't hold it against the defendant. And so it's at that point that the prosecutor says, I don't need to challenge this jury. And of course, Attorney Sack then does, in fact, challenge the Indian jury. So those are my points on the peremptory issue. Are there
By the
further
way,
questions on
just
either?
one last question. So
Yes,
the
sir.
consequence, so in your brief, you talk about this being a second-degree murder, but if we think this is a Baxter case, this is an acquittal, right? There's nothing, because there was no accessory after the fact charge here, right?
No, there was not.
And that's not a lesser included. So we're dealing with all or nothing here.
Right, yeah, at most you could say assault, but it's not, there's, unless you find that he knew that they were armed and he knew that they intended to commit shooting, yes, it's a required finding if not guilty. But again, based on the facts set out in brief and the facts that I've mentioned here, I urge this court to affirm the judgments.